Hello everyone, my name is Siddharth Bhatt. Welcome back to my new video. Today I would like to speak on inheritance without a will. Now whenever a senior member of a family dies, or whether it be due to old age, disease, or other members of family die in unfortunate circumstances such as an accident and so on, then it is normally expected for him or her to leave behind a will, essentially a legal document where he stipulates to whom he is expected to he is leaving whatever assets he has in their possession in specified order. However, there might be some unfortunate circumstances where either because of his or her illiteracy at the time of his death, or due to some factors such as his death being so sudden that he didn't have time to leave behind a will, or he just couldn't think, or any other reason whatsoever, he couldn't leave behind a will, or he did leave behind a will but nobody could find it. So this is essentially called interstate succession. As in, this is the in legal parlance, that person who doesn't leave a will behind on his death is said to die interstate. So this video talks about what alternate legal procedures you have to follow in India if you did not leave behind a will at the time of it. As in, your successors, whoever they were, if they did not find a will left behind by the deceased person at the time of his death, then what legal procedures they have to follow. We'll speak on this. Now, I would like to first speak on what is intestacy first. Moving ahead. Now, uh, intestacy is a word that is very common. Like, although not very common, I would say in legal parlance, though this word is often used, particularly in succession law. Those of you who are laymen or who would not have known this term before, unlike those of you who are law students or legal professionals. So for the benefit of the general public, the layman, I would like to say what is intestacy. This term is specifically defined in the Indian Succession Act 1925, which governs succession in absence of a will as a person is deemed to die intestate in respect of all property of which he has not made a testamentary disposition which is capable of taking effect. To put it simply, what I earlier said, if for any reason, whether it be illiteracy or sudden death without any time to draft a will, he said that he didn't leave a will behind, or he just or any other reason whatsoever he couldn't leave a will behind, or he did leave a will behind but it couldn't be found. So in legally so legally speaking, he's said to have died intestate, or put it simply, without a will. Now moving ahead, when it comes to succession without a will, our Indian there is a detailed Indian legal framework for succession in absence of a will. There are many laws which govern this. One is the Indian Succession Act, which was formulated in the British era way back in 1925. You could say it's kind of the base law for interstate succession. Or after independence, Hindu Succession Act 1956, which governs the interstate succession relating to Hindus. Then of course other people of other religions also have their own laws, like Christians, Parsis. They have they for them it is usually the Indian Succession Act which specifically applies, but they have their personal laws as well. Then Muslim personal law for Muslims. There's a succession. There is succession laws specifically related to Muslims are there. Then governing personal laws, as in, like I said earlier, various religions, they have their own personal laws. As this especially started during the British era, because the British, they deigned to rule Indians based on what religion they belong to. They classified Indians based on religions. So to govern Indians of various religions more effectively, they allowed those Indians to formulate their own personal laws with their own with their encouragement, of course. Sometimes the British themselves took it upon themselves to draft laws for specific religions and enforce it. Then there are others also. Then there are two documents which specifically relate to this. One is succession certificate. The other is letter of administration. So succession certificate. This usually relates to a disease movable assets, namely securities, debts, and all. Essentially, stuff which is not tangible, but which are deemed movable, as in transferable and so on, something which is easily recoverable. The letters of administration, this usually relates to court. Essentially, if you apply to the court in the absence of a will, the court, after certain procedure, it grants whoever deems suitable to administer the property of the deceased, as in where the court appoints a certain person to essentially be a, you could say he's essentially a sort of trustee, not trustee, I would say he essentially becomes the de facto owner of that property, even though the person didn't whoever had died, he didn't plan on making a success or anything, but the court deemed him suitable, so the court appointed him as the administrator or owner. Succession certificate essentially relates to disposing of debts and more securities and all, but more on all of this later. Moving ahead. So, dying intestate, there are very serious consequences if you happen to die without having left a will behind, or if your will wasn't found. One is the whenever a person dies and he leaves behind property, he usually has had intentions in mind, like if he deems, if a certain family member was his favorite, or he deemed him most suitable to be in charge of his property and all, and he wanted to leave that behind, but because he couldn't leave a will behind, or he neglected to leave one behind, so what happens is, even if you if the court's intervention in this matter may not exactly align with such disease intentions, the court will obviously decide on the basis of the succession laws. The court won't necessarily take into account what exactly were the deceased person's true intentions, or for that matter, what were the relationships we had, what kind of relationships he had. The court might even end up, God forbid, leaving the giving away the property to someone to whom the deceased did not want to give that property at all. Then next problem is complex probate delays. Like I said earlier, what happens is, in the absence of a proper will, you are required to file an application before the court to determine the distribution of the deceased property, which means the court intervenes in this. So the court obviously takes its own time. God knows the court has plenty of cases. This usually happen. This sort of case is usually taken before family court. So family courts have to deal with divorce cases or all sorts of other cases, which means they can't devote their full attention to this. So the court usually takes its time, at the least 5 months, sometimes even more, depending upon how much time it has. So again, the distribution of assets in the absence of a will could be unnecessarily delayed to the inconvenience of all family members. Then again, third problem is increased dispute risk. Obviously, a will makes a thing simpler. Once a will is made and the distribution of property is stated in full detail in the will, it is final. A will cannot, nobody really bothers disputing a will. I mean, people do, like based on if the person was mentally sound or not at the time of making the will, but most of the times a will is final. Nobody wastes their time disputing a will. However, if a will is not there and if you take the succession matter before the court, that could lead to very hostile disputes, as in it could lead to unnecessary tension, unnecessary disputes between family members, all of which would be a waste of time, as all of which could really have been avoided if the deceased person had bothered to leave a will behind, or at least had asked his lawyer, whoever was his trusted lawyer, to draft a will for him based on his intentions. So essentially, without a will, dispute the chances of high intensity property disputes are much higher. Not to And the longer a dispute goes on, the longer what probably was good family relationships, they get unnecessarily strained and spoiled. So again, dying without a will is really bad, so to say. But sometimes it happens, so we'll just go ahead and talk about what to do if any person dies not leaving behind a will. So first of all, the like I said earlier, in the British, starting from the British era, there were several personal laws relating to various religions. Basically, whichever religion person belongs to, that religion's personal law applies to him. Every religion has its own personal law. The Hindu Succession Act 1956, drafted post independence, it usually applies to people it considers Hindus, essentially those who are mainstream Hindus, then branches of Hindus, namely Buddhists, Jains, Sikhs. If you look at our Indian constitution, at the very beginning, Hindus, those who are designated Hindus, they do include Buddhists, Jains and Sikhs, since historically speaking, they were part of Hinduism before they branched off. Then the Indian Succession Act. The Indian Succession Act, drafted in the British era, this usually governs the other religions, namely Christians, Parsis. There are other minority religions also, such as say Jews. There are a certain number of those do exist in India. Then there are essentially other religions who do not have their own specific personal laws. Then obviously, then last, there is the Muslim personal law, the Sharia law, which dictates inheritance. This law is specifically applicable to people following the Islamic religion, and this limits testamentary disposition, as in Muslim personal law limits the uh, disposi the disposition in absence of a will to 1/3 of the deceased wealth. Now moving ahead, as per the Hindu Succession Act 1956, for those of you who belong to the Hindu religion or Sikhs, Buddhists, Jains and all, like I said earlier, there is a hierarchy in the order of inheritance in absence of a will. Now this hierarchy is followed to prevent any unnecessary disputes. So who are the primary beneficiaries first? The primary you could say these are called class 1 heirs. Class 1 heirs being those who get first priority in the inheritance of a deceased property in the absence of a will. The class 1 heirs usually include, if it is a man who has died, then the widow of the deceased, or the widower if it is a wife. Usually the Hindu Succession Act implies the disposition of property on the deceased husband's death. So taking on the presumption that it's the husband who's died. So if the husband, if the man of the family who dies, his widow comes under the primary beneficiary. Then all of his living sons, then the man of the her family's mother, essentially his widow, his sons and his mother, they all come first in the succession ritual in the absence of a will. So so in the absence of a will, those who are class 1 heirs, they can apply to the court and have the property divided among themselves simultaneously. So each heir will take his or her own share based on what the court decides. Now, when it comes to Christians and Parsis, and other religions who don't have their own personal laws. Uh, the Indian Succession Act 1925 governs this, and this is for both the assets which are movable or intangible and which are immovable, such as land, buildings, and so on. So, as I already defined, so this act, Indian Succession Act, is what governs succession for Christians and Parsis. So, when it comes to interstate succession, one of the primary documents is letter of administration. So, as I said earlier, letter of administration is a court-administered property when a dispute, when in the absence of a will, the succession matter is taken to the court. After a couple of hearings, the court decides who is most suitable to be in charge of the deceased property and issues a document called letter of administration. Now, should you want to view the full act details, you can view this act at details, namely https legislative.gov.in.sites default file. This is the act which primarily governs basically if you want to, should any member of your family have died without leaving a will behind, you can you can essentially go to this link and you can look for the matters in further detail, or you can just consult any legal professional you are familiar with. Now moving ahead, now succession certificate. What is a succession certificate? Succession certificate is when if a deceased had movable assets, namely he had debts that were due to him from others, or he had securities, namely debentures and so on, which are in the nature of debts. But and also movable bank assets, namely bank accounts and so on, and he happened to die without leaving behind a will. So there is a standard legal procedure. So essentially there is a procedure for this, for claiming ownership of all these assets. Should he die, should the deceased have died without a will. So for movable assets, you have to obtain a document called a succession certificate. So what is the procedure? Number one, as I said earlier, in whichever area you're residing in, if there is a district court there, you have to file a petition with that district court. You have to first detail all the matter in full, namely the disease, the complete details of the disease, and a complete inventory of all of his debts and securities and other movable bank assets such as bank accounts and so on. Then what was his relation, what sort of relationship you enjoyed and so on, all that relevant details. You have to incorporate it in that petition and file it before the district court, and you are required to pay the court fees during about that time. The court fees usually amount to when it comes the court will calculate the value of the entire inventory of the assets you have submitted, and on the basis of market value or whatever other estimates the court will take, it will decide the appropriate value, and you have to pay something like minimum 2%, maximum it could stretch up to 5% of the value decided by the court, and of course you have to pay the required stamp duties that it decides. Then after once the court fees are paid, once the petition is finally submitted, the court will issue a notice to all the involved parties. Essentially, if the court examines the matter and finds that there were other parties who could have a potential stake in those assets, then the court would call upon them and hear their testimony. Then um, uh, hear their testimony. Essentially, before all that, it would issue a notice to those parties. And if it is unable to trace those parties for any reason, it could also publish a notification in the local newspaper in any local media in the local language. Then the hearings would begin, of course, just like any other normal case that goes on in court. The court would call upon all the involved parties, hear their testimonies. Then after all the hearings, then it would also take into account all relevant evidence that it receives. Then evidence that usually pertains to when it comes to the applicant, whoever has applied for the succession certificate, what sort of relationship they enjoy with the applicant, or more particularly what they enjoyed with the deceased. Was it more likely, was the deceased more likely to leave the property to the other parties rather than to the applicant, and all that. Then mostly the evidence that they would want is to ascertain whoever has applied for the succession certificate, would the other involved parties have any objection to the applicant receiving the certificate, or applicant being in charge of those assets. Then later on, after quite a period of hearing, usually within a couple of months, 5 months to take it, then if the court is satisfied that the applicants has a full legal right to those assets, then the court would grant the certificate, putting the applicant in charge of all those assets, giving him the full right to not just to receive the benefits of those assets, whether it be interest or dividend, or right to receive repayment of debt and so on. Now, moving ahead. Now, letter of administration. This is again a court administered document which is issued to an applicant who wants to be in charge of the deceased property if the deceased happened to die without a will. Again, the difference here is unlike now this looks familiar, right? We already dealt with succession certificate. So what's the difference here? Difference is succession certificate only and only deals with movable assets, primarily debts, securities, bank accounts, and so on. Well, now, but if when the deceased person died without a will, he would also have left behind certain immovable property like land, buildings, flats, and so on. Now those are immovable. The succession certificate doesn't cover those. Now, if he died without a will, who's there to look after that? That's what the letter of administration is for. Now, there's a procedure for this as well. What's the procedure? Number one, yeah, you are required to submit an affidavit before, like in succession certificate, you have to go before the district court of wherever you are staying at, and you are required to provide an affidavit when as in during the process of filing an application for this document, letter of administration, you are also required to submit an affidavit, and that affidavit has to confirm that whoever is the person or deceased person, he is actually dead. As in, you might be required to submit your ID proof, Aadhaar card, or anything. You are required to submit the death certificate of whoever died, and you are also required to affirm in that affidavit that he died without leaving behind a will. And along with that affidavit, just like in succession certificate, you are required to cover a full inventory of whatever assets he left behind, movable and immovable. Everything that he had in his possession, which he left behind on his death. Then once the court takes all this into account, it's required to publish a notification, usually a newspaper advertisement stating that there is someone applying for a deceased person's property inheritance, and the deceased person didn't leave behind a will, and does anybody have any objections, and so on, just like in succession certificate. And later on, the court would you could say the court would start on hearings. The court would conduct hearings. It would call upon parties to ascertain as to whether they have any objection to the applicant inheriting the property, or if they do have objections, then why. Then it has to take into account evidence detailing the disease relationship with the applicant and with the other involved parties. Then if the other parties have any objections, has to incorporate all those objections. Then after a couple of hearings and so on, again like in succession certificate, it is usually 5 months or so. It would issue the letter of administration. It would grant whoever applied for it full authority to be in charge of all of the property of the deceased, as in both movable and immovable. Essentially, if whoever is in applied for it, if his application is successful, he would be in charge of the entire property with full authority of the court. Now, when it comes to we have talked about these two documents. Again, like I said, there are differences between these two documents, the succession certificate and the legal administration. One, as I have said earlier, succession certificate only and only covers movable assets, primarily debts, securities such as debentures, shares, and so on, or bank accounts and bank accounts. However, letter of administration is far more encompassing. It includes the entire spectrum of property. It includes the land, buildings, flats, other movable property as well. So if anybody died and he also left behind immovable property, it is better to apply for a letter of administration in absence of a will instead of a succession certificate. Then the primary purpose of both of them. One is when it comes to succession certificate, the primary purpose, since this relates to debts, immovable debts, securities, and bank accounts, especially debts and securities. This is the primary purpose of succession certificate is to be in charge of receiving the debts from the debtors, or if security, in case of securities, you could sell the shares and debentures and receive the amount, or you could keep them and receive the benefits of interest or dividend and so on. And when it comes to letter of administration, since this also includes immovable property, the primary purpose is to be in charge of that property and to manage the deceased property, and if you want to distribute it to other family members based on your preference, you could do that. Ownership. Okay, like I said, ownership. Succession certificate, it is important to imply it does not confer ownership of any kind. When it comes to movables assets, it doesn't really confer in. Usually when a succession certificate is applied for, it is usually just to receive immediate benefits. Like it would be expected of you that if you are in charge of securities or debentures, you are expected to simply receive interest on them, or if you do not like those securities and want to sell them off immediately to receive the immediate money, you are expected to do that. So it essentially, if you receive a succession certificate, it doesn't necessarily mean that you are the owner of those securities and debts. It just means you have the authority to collect the monetary benefits on them. That's all. Then, however, letter of administration, since this also relates to immovable property, here the primary purpose is to cement your ownership of that property. So, it is better to apply for letter of administration if you really want to be the legal owner of the deceased property. So again, different parts of the Indian Succession Act govern both of these. Part 10 of the Act governs succession certificate, and letter of administration is governed by an earlier part, part 8. Okay, moving ahead, like I said earlier, when it comes to financial and temporal costs, there are costs. If there is no will and you take it to the court would expect costs to be paid to it. Now, average court fee usually depends on minimum 2% to max 5% of the value of the property for which you have applied for ownership before the court. Again, this depends on state to state. Every state has its own fee percentage. for payment fee percentage for the filing the petition or application. Again, the duration. Again, here the duration varies. The max duration, like I said earlier, is about 5 months, 150 days, give or take. Minimum is at the least 45 days. Then those of you who are Muslim, who belong to the Islamic religion, there is a limit under Muslim personal law to how much of wealth you could dispose of, even by means of will. It usually relates to about 33%, as in you could say, put it simply, 1/3 of the value of the deceased property. Then what is the timeline for estate recovery? For in the first month, the court would ascertain in the first month of shortly after you have filed a petition, the court would verify whether a will is truly absent. Sometimes it may happen, like I said, that the deceased person might have left behind a will, but for some reason it couldn't be found. So the court would properly verify if a will was in fact left behind or not. And if it is fully verified that there was no will at all, then the court would take the petition into account and also identify the religion of the parties involved and the governing personal law. Then when it comes to filing then in the initial month, the court would identify all that. Then later on, in the second month, and then later on in the next month, the court would, if a person has filed a petition for succession certificate or letter of administration in the whatever district court is present where he is residing, then the court would take all of it into account. He would take the petition and all the submitted documents into account, ID proof, inventory of assets and so on, and then it would file the petition in the second month. Then between the third and fourth months after the assessment was done, the court would issue a public notice in newspapers. This is usually for those parties who are involved in this succession matter. If any potential parties who are involved, they can come to the court. They can state their objections. They can provide evidence in hearings relating to what the actual relationship the deceased had with the applicant or with them, and what sort of, and if they have any objections to the applicant inheriting the property. Once it's done in the final month, in the fifth month, then after one final hearing, if the court is fully satisfied with you, with your application, then it would issue the succession certificate, and which the succession certificate or the letter of administration. In case of succession certificate, it would be transferring all the assets to you, or more importantly, if the deceased had debts, authorizing you to collect debts, or in case of letter of administration, making you the full legal custodian and owner of the property. Okay, now moving ahead. As I've said earlier, when it comes to interstate, or putting it more simply, without a will succession, there are several risks to it. One is, since to apply for succession certificate or letter of administration or any other matter to which any other personal law applies, you have to take this matter before the court. So obviously litigation means a protracted legal matter. It might not necessarily be 5 months. It could even extend longer depending on how packed or busy the court calendar is. And the longer the matter goes on, it could be that it might lead to a property dispute among various potential heirs or family members. It could turn bitter, hostile, meaning the whole thing could really go on for a lot longer than it would have happened if there had been a will present or found. Then obviously the court case could go on for longer. More importantly, hearings mean you have to pay the fees to the court, and not just court fees, but also if you hired a lawyer to defend you, you are required to pay the advocate's fees, which means that legal costs would become so much more that whatever estate was there in dispute, the you might be required to pay out of it, or pay out of whatever assets you had in your possession, which means that the continuous legal cost might actually result in the reduction of the value of the deceased property, which means at the end of the whole thing, the property might not become worth inheriting in the first place. So that's the problem. Another problem is financial hardship. Like I said earlier, prolonged court cases mean extended more court fees, more counsel fees, as in fees you have to pay to your advocates for defending you. Then more importantly, the assets of the deceased during while a court case is going on are frozen. They are, as in they are not accessible to the disputing family members. So which means that for as long as the case goes on, nobody can access the deceased property, and if the deceased property is worth crores or millions, then that means that disputing parties can't really access those benefits. And if they are in need of money, the disputed property might have provided the necessary resources to satisfy, to ease the hardship. With those resources, with those assets inaccessible, the hardship would increase even more. Then another risk is, at the end of the whole matter, once the court decides on a succession, on who is the appropriate successor, the court will take into account the laws and various other matters, primarily the applicable laws. However, what's the problem here is, whoever died, he may not have had the court's intended successor in charge. He might have wanted a different person. Let's say a father died, and we have already seen with the Hindu Succession Act, the primary beneficiaries are the widow, the sons, and his mother. But what if he had a favorite daughter? What if the daughter was the most capable member of the family, and he wanted that property to go to her, but because he was illiterate, or because he died suddenly, that he didn't have the time to leave a will behind, the property went to the others, to the heirs whom the law decides, not the deceased person. A will is more advantageous in that aspect, because in a will you can actually state whom you want to leave your property to, and the will carries the full weight of the law. If you take a will to any court or magistrate, there would be a dispute based on the will, but mostly the will is taken as final. Usually they would decide, even if a will is in dispute, such as for any reason, such as the mental capacity of the deceased person at the time of his death, either way, those are pretty rare. Either way, the will is held as final in all aspects. So a will gives the deceased party more power in that way, which the law would take away from him, because the law has its own parameters and the deceased has his own parameters. So again, dying without a will, it is a great crippling factor for the deceased, and also for the living in a way. So moving on. Those who are experts, what would be my personal recommendation? Not just those who are experts, or there are other experts out there who would recommend the same thing. So now a recommendation number one would be will creation. Instead of dying without a will, those of you are still alive, or those of you who think are going to die soon and want someone to inherit your property, someone you deem is suitable, it is better to draft a proper comprehensive will. Comprehensive meaning a detailed will, detailing to whom this asset should go to. So that's the only way. What happens if you leave a will behind? The courts and other legal authorities would usually take the will as final. The will would not be disputed, so you can distribute the property to whomever you want. So after you die, it avoids unnecessary complicated legal procedures relating to interstate succession. Then if you don't, then even if the deceased party does happen to die without a will, it is better to seek expert legal counsel to navigate nuances, as in navigate certain finer details of the, especially when it comes to Hindus and Muslims, they have very specific personal laws applicable to them. So sometimes we may not necessarily be aware of what sort of details would exactly be applicable to us. So it's better to consult your lawyers and all to find out exactly what sort of law would apply in case the deceased party died without a will, and how to go about these succession matters. Again, there is a link that is provided here. This link, it is called https www.india.gov.in. This link, this is essentially a portal which relates to succession. You can access this portal if you want to find out how to go about the succession matter. Sure, interstate succession matter. If whoever in your family has died and he hasn't left a will behind, then if you want more information on this matter, you can just access this website. Then again, like it is better last and foremost, just to make this clear, although I have covered this matter relating to interstate succession, my personal advice would be those of you who are near death, those of you who think would die soon, it's best to leave a will behind detailing what sort of property you have and to whom do you wish to leave to. For what I have stated earlier, your will would be fully validated by a court. Your will would not usually be disputed. By contrast, if you do die without a will, you might find your living successors might have to fight a protracted, prolonged legal battle for no good reason. And whoever the court appoints as a successor, that successor might not necessarily be what you wanted in the first place. So it's best to draft a will. That's what I say. Draft a will. Make sure you leave your property behind to whoever you want to succeed you. That's so. If you want any further information on this matter, please visit this website https://legalaffairs.gov.in. Here you will get all the information you want relating to this, or if you want, you can just contact if you are if you think you are going to die, if you do not trust the online forums or the online websites, even I wouldn't trust it necessarily, because online information is somewhat dubious. Any person posts whatever they want, so it's best to consult your lawyer, as in whoever a lawyer you know with good credentials, or whoever lawyer you are most familiar with, whom you know to be reliable and all. Consult him and find out how to draft your will, or if you or have him draft your will for you. You can just state whatever are your intentions, or ask him to conduct the succession matters properly. For some reason you can't leave behind a will, although like I said, it's best to leave a will behind. So to a long and short of it is, just leave a will behind in case you think you're close to death, or if you're not close to death, but whoever you want to leave the property to, just in case as a precautionary measure to avoid any further risk. After all, death could happen anytime due to any factor like accidents or sudden diseases and so on. So it's best to always leave a will behind. That's what I'm saying. So thank you all for watching my video. Please subscribe to my channel. Please like this video if you can, and also if you can, please subscribe to my channel at Siddharth 4898. Thank you all for watching this video. Thank you.